5 seconds to go. Start. The trial court held that the statements of PW2 Jagdev and PW3 Hardev were relevant and not merely hearsay evidence, and their statements would not be unreliable merely because they were relatives. The delay in filing the FIR was held to be explained as the complainant was proven to be unfit to make the statement on the day of incident. The court further noted that though the accused claimed to have been injured, they had not filed a complaint or put any suggestion regarding the same to the prosecution witness. The injuries on the accused were simple in nature. The court held that the conduct of the accused in travelling 1 kilometer from their house armed with a gandasa and inflicting injuries on the complainant proved their common intention, and the medical evidence proved that the injuries inflicted were simple and in one instance grievous in nature. The trial court convicted the respondent and sentenced him to rigorous imprisonment for 3 years with fine of rupees 1000 for offence punishable under section 326 IPC, and rigorous imprisonment for 1 year with fine of rupees 500 for offence punishable under section 323 IPC, and Lavkor was also convicted under sections 326 and 323 IPC, read with section 34 IPC, and awarded the same sentence. Aggrieved by the judgment of the trial court, the respondent and his wife preferred appeal to the Sessions Court, which noted that there was documentary evidence proving that the accused and complainant were treated by the same doctor. The presence of the accused at the crime spot was held to be proven. Lavkor had no injuries on her person, and 6 injuries on the respondent were held to be simple, and its known explanation was held to be not fatal to the prosecution case. The Sessions judge held that though PW2 and PW3 reached the spot afterwards, the statement of the complainant was enough to conclude that it was the accused who inflicted the injuries. The Sessions judge, however, held that the finger injury was erroneously held to have been grievous, as the radiologist who conducted the X-ray of the said injury and whose report was relied upon by PW6 to hold the injury as grievous was not examined. The Sessions Court set aside the conviction of the accused under section 326 IPC, but upheld their conviction under section 323 IPC, upholding other findings of the trial court. The Sessions judge also noted that Lavkor was an old lady who herself had not caused any injury to the complainant and was a first time offender and released her on probation on a bond of rupees 20,000 after setting aside her sentence of imprisonment with fine. The respondent was, however, sentenced to imprisonment of 1.5 years with fine of rupees 1,000. Aggrieved by the judgment of the Sessions Court, the respondent preferred revision before the High Court. The respondent did not challenge the order of conviction but sought reduction of the sentence awarded to the period of imprisonment. Stop.